So, thank you. Well, I would like to thank the organization for this kind invitation to talk about the topic of my presentation, International Labor Law, Emerging Technologies, a comparative view from the EU-Brazilian relations. And first of all, it's a huge, I would say, effort to speak in English for a Brazilian-Italian audience, but the purpose of this lecture was also to disseminate the knowledge behind the project conducted by my esteemed colleague, Professor Maria Rosária Barbato from University of Minas Gerais, and also under the framework of the CIDO project, Safeguarding of Employment Digitally Oriented Workers, and also the Jean Monnet module conducted under the auspices of the University of Minas Gerais. So it's a very important part of this work, and also to highlight the importance of the topic on international labor law and emerging technologies for the research agenda, which is also developed or carried out by the researchers, doctor students, and also staff professors of the University of Minas Gerais graduate program in law. So basically, the idea here is to focus on 4 parts of this presentation, which deals with the background and key concepts around the work performed in or within the digital platforms. And second, to understand the main use cases and potential risks to the enjoyment of social rights of the employees and also the workers as protected by international treaties, as protected by domestic laws, dealing with protection or social protection of workers, and also, which is most important for the relationship between European Union and Brazil in this dialogue, is to focus on comparative perspectives of this particular topic. So hopefully we are going to check how, or currently in the international legal arena, also talking about the International Labor Organization, ILO, and also the European Union and Brazil are connected in this particular topic. So this is a very, I would say, not only emerging topic of research, but rather it's a topic where the international legal norm setting, international legal standards are concerned nowadays. And I'm just referring to a very important aspect of the international legal norm setting or the international lawmaking, particularly under the ILO, the International Labor Organization, which has to do with the current negotiation of the first binding instrument by the ILO, which is a very controversial topic, and not a recommendation, non-binding instrument, but a binding instrument relating international obligations to protect workers in digitally platform work carried out by those employees and workers abroad. So this is also something that we have to have in mind when we are discussing the potential, I would say, future and avenues for international labor law connected to the digital interface with labor, which is one of the main topics of the international legal agenda or norm setting carried out by the ILO. And I'm just talking about ILO because for many years, I have been involved in research of private international law aspects related to international labor law. So the connection or interface between private international law, which is the subject that deals with issues related to applicable law, jurisdiction, recognition and enforcement of foreign judgments, international mechanisms of judicial cooperation in civil, commercial, labor, administrative areas. So labor law is also intrinsically, inherently connected with private international law issues. On the other side is international labor law that can deal with the public dimension of relations between the protection of labor as such and work as such, and from the other side, the relationships between states, international organizations for the public dimension, and also from the private dimension of international employment relations, industrial relations, as the unions and so on and so forth, from the individual and collective rights of the employees, also in relation with the work that's carried out by the International Labour Organization, which is by chance one of the oldest international organizations that we know. So before talking about the European Union in Brazil, it's important to understand from the framework of the international legal framework that we are dealing with issues that today or nowadays the International Labour Organization is also dealing with. So international labor organizations, the ILO, is now concerned and working into distinct aspects of this agenda that has to do with digitally integrated or digitally labor in relation to what is the project that we are here developing. And the first, of course, is related to the work that the ILO has been developing in two agendas. First is the decent work agenda, which ensures that the International Labour Organization in the member states, also the unions and the trade unions from the industry, due to the three dimensions or tripartite organization of the International Labour Organizations are concerned. So this is basically one step further to this agenda that's now under the work of the member states and also the diplomatic conferences of the ILO from the public international labor dimension, but also one important step which has to do with the recent negotiation related to a binding treaty involving the member states and also the ILO as such, which has to do with this particular convention, which is today one of the most important aspects related to the work carried out by the ILO. And of course, before talking about the comparative perspectives between EU law and the digitally work dimension, what's behind the work conducted or carried out in digital platforms, how employees or how workers are protected, or how those rights are recognized under domestic laws, which is also a very sensitive issue in Brazil due to not only the legislation that we have in force, the consolidation of the law, of the labor law in Brazil, the CLT, and also the treaties which are signed by Brazil, ratified by Brazil, and are enforceable within domestic level, but also in relation to European Union, three important developments that are under this umbrella, this comprehensive umbrella that we are talking, that has to do the Platform Work Directive, the PWD, the AI Act, the Artificial Intelligence Act, or the EU regulation on artificial intelligence, which has been recently adopted and entered into force in the European Union, and also the GDPR, or regulation on data protection, which is also one of the most important pieces of legislation that would protect individuals and also workers as such, employees, in those relations, legal relations carried out in digital platforms. So this is something unique in this particular comparative approach, because we are focusing on legal comparative aspects related not only to recognition of the employment relations within the platform work environment, but also how to ensure a level of protection of social rights in human or fundamental rights concerning the labor relations or employment relations, when the employment is recognized under the domestic law, the law applicable to those relations, which is something also very I would say a unique distinctiveness, distinct approach to how those legal relationships embedded or coming from the relations, the work relations are concerned. Me, myself, am not a specialist in pure domestic labor law, but rather my focus has been on the relationship in international law, labor relations. In this case, the relationship between private international law and international labor law, which is a classic subject in this field. And the idea is to understand how under the framework of the CEDAW project, if we are talking about safeguarding employment and digitally organized workers, how this axis, how this important interface will, in the end of the day, speak, dialogue, or interact with the international legal norm setting and also enforcement mechanisms. Because what is very important in comparison with EU-Brazilian relations in this field is to understand how officially institutional enforcement mechanisms are available by the member states of the European Union and Brazil in this comparative approach to make effective the right or social rights and the social protection of the worker, which carries out his or her tasks in digital integrated platforms, digitally integrated platforms as such. So the idea is to understand the context and how those instruments and legal binding instruments, for example, the international treaties, the regulations, directives in the European Union, in Brazil, the domestic law, but also international treaties, which also Brazil signed, ratified, and put into force into domestic law by the incorporation mechanisms that Brazil has today for those instruments, for the international treaties, and also in particular treaties that our Supreme Court in Brazil already decided as having the supra-legal hierarchy in relation to domestic infraconstitutional law in cases of human rights or human rights treaties that have materially fundamental rights, norms or rules in. So this is something that's also a uniqueness of this comparative legal approach, which has to do with the knowledge on how international labor law operates, first of all, the knowledge of how international instruments, particularly treaties and convention, would be binding to Brazil in such relations, but also binding the European Union, because the European Union has to deal with two dimensions. One is related to the intra-community instruments, the regulations, directives, and also the treaties establishing the functioning operation of the European Union, the treaty establishing the European Union, the European Charter of Fundamental Rights. And so those, I would say, overlapping because they can be somehow cumulative in terms of how they will be enforced, how they be applied to in relation to member states, but also in relation to member states in third countries like Brazil to European Union as a third country. So in these external relations between European Union and Brazil, for example, in the field of international labor law, especially private international labor law, will be those relations in between member states and a non-member state. In this case, Brazil as a non-member state. I'm talking about that because the work carried out through digital platforms is a cross-border technically service or work. And for that reason, this cross-border nature of the work that can be carried out by a worker here in Brazil, but hired by a platform which is based in European Union, for example, entails an international labor agreement or employment agreement or international services agreement if it's a case of outsourcing. So those the comprehension and also how we understand it and how we capture the reality of those transactions, legal relationships between the individuals as workers, and on the other side, this service provider or the one who is hiring this particular worker to perform typical working tasks within a digital platform or by means the digital platform is something very important in this sense. So the first, I would say, message of this presentation would be the following, that if we are discussing issues related to the safeguards of employment and digitally organized workers, from the standpoint of individual rights, I would say individual labor rights or collective labor rights, we have to deal with this. Caiu. Yes. Vamos ver. Aconteceu aqui. Não, eu tô vendo aqui, não precisa não. Eu só conectar. Yes.
We can hear you, Professor. Huh? We can hear.
Yes, we have a small interruption here, but now I'm back to the Zoom session. So I would just recap what I said before. The idea or the main message of this presentation would be the following, that when we are talking about safeguards of employment and digitally organized workers, under this very important and unique topic, international labor law agenda, we have to understand, and this is why I have been insisting on this particular topic, this distinguished or distinct relationships between what is behind international treaties, conventions applied for the laborers, applying to the workers, and also ensuring a level of protection or social protection to the workers, especially those who are workers domiciled or residing in member states of the ILO in the first instance. And second, the second dimension would be focusing on those relationships between Brazil and European Union in their particular legal systems and what is also apart from this. But even if we are talking about what is behind international labor law, so treaties, conventions, international standards for protection of work, and also when we are talking about the EU directives, regulations applicable to the European member states, or where we are talking about Brazil, especially Brazilian legal system and the law applicable to those legal relationships involving the workers and the employers in that particular aspect. We are also focusing on commonalities or common denominators of those, I would say, factors or features involving those legal relationships involving workers in digital platforms. And that's why it's important to understand, because we are not only talking about, for example, the classic, now already classic, I would say, concept involving Uberization or Uber-based work for defining generally what is about the work performed or carried out within digital platforms by an individual, which is a worker in the end of the day, or who can be an employee, depending on the law applicable and how the applicable law defines the employment relation, as we know. And that's why those categories are so disputable, are so controversial when they are put into negotiations within the scope of the norm setting in International Labor Organization by member states who have traditionally a history of social protection of workers, like many countries in European Union, like Brazil, while other countries, member states of the ILO, wouldn't have the same approach, I would say, dealing with the social protection of workers, or due to several waves, trends of reforming labor law or social rights or demising, eroding, or I would say downgrading social rights within their particular legal systems, they will have, in the end of the day, different conceptions or interests in support a position which would be against the recognition of labor rights, in particularly the rights of workers within those digital platforms. So to say, in very simple words, there are some member states of the ILO which will support in their diplomatic negotiations a lower degree of protection of workers carrying out those labor or working activities within digital platforms. And so this is something unique. I will just shortly stop here because I have another disruption of service here from the Zoom. Just a moment. Vocês estão me ouvindo ainda, não?
Sim, professor.
Sim.
O áudio está perfeito. A conexão também.
Só para eu resolver aqui a questão do... Depois nós vamos compor esse vídeo para tirar, editar o vídeo para tirar essas interrupções. Só um momento. Just a moment, please. We just have here disruption of Zoom. Yeah, it's not working.
Recording in progress.
So now I'm back here. Well, me ouvindo? Tudo certo?
Tudo certo, professor.
Ótimo, obrigado, Stefano. Desculpe.
De nada, imagine.
So the second point of this presentation is to focus on several key concepts, categories, which are nowadays have been discussing in the current topic of digital work, and also particularly the work carried out in digital platforms. One of the main case uses that I would say, legislators, public policy makers, and also the unions have been identifying in this exploratory work that also was somehow presented during the negotiations of the ILO draft treaty or on work in digital platforms, was related to a very unique concept that has already been disseminated throughout the legal research agenda in labor law, particularly the labor law in the interface with emerging technologies, which has to do with the concept of algorithm power and algorithm subordination, which is something very, I would say, unique in terms of how labor law categories were reframed, redesigned based on the real experience and context of the work carried out by within the digital platforms. In order to say how workers are interacting with those digital platforms, and therefore how this interaction between a user, a citizen, a consumer, a client, and in this case, the worker as individual, with these new structures and frameworks, designing the way how typical working tasks are performed or carried out in these platforms. And that's why digital platforms using algorithms to task assignment, to pay setting, to monitor workers, or even to deactivate the way how those workers are integrated with these platforms, which raises risks concerning the opacity of those platforms, bias, the intensified work, the lesser time or useful time for working and having leisure and having rest and disconnecting, which are some categories that are also evolving. For example, the fundamental right to be disconnected, which is a right that evolved from the recognition of the case law in France and in Spain in the 20s, and then in the 2000, in the decade in 2000, and then evolved to special legislations in those countries like France and Italy, that in France and Spain, that originally for the first time defined this under statutory law, statutory labor law, and predefined this right to be disconnected or to disconnect, which is something which clashes or conflicts with the power of digital platforms to control, deactivate, or even to suspend, apply penalties to those workers, which is something very important in terms of how the enjoyment of social rights in digital environment that have been recognized in the last 3 decades, almost since the advent of internet, and the way how internet governance mechanisms also interacted with human rights conventions, treaties, and how those new categories of fundamental rights online were developed on one side. On the other side, how the emerging algorithm power and subordination that are features or characteristics of those platforms are now clashing and I would say putting these rights against the wall of enjoyment, against the wall of enforcement by traditional mechanisms. So if we go and workers go and plea before the courts, arguing, for example, infringement or violation of their individual rights, individual labor rights, they would be confronted with legal defenses coming from those platforms saying that they didn't close a employment agreement as such, but rather that they adhered or they opted for a terms and rules of the community. So basically understanding of how the relationship between those instruments from the traditional employment agreement from one side or labor contract, and the other, the simple adhesion or acceptance of terms of uses or terms and conditions, as if those relationships would be also downgraded from the traditional labor perspective or employment relationship from one side, recognized and enforceable according to the applicable labor laws, and on the other side, the as I mentioned, this downgraded category where this is about a service agreement or a typical civil legal relation between the worker and the platform, which has to do with all the legal reforms that have been carried out and developed within domestic legal systems. In Brazil, this is not different. In combination with bill of legislations, projetos de lei, in Brazil that are now under the scrutiny of the National Congress from one side, and also from the other side, a very, I would say, I will put in a very simple term, but this is a very also critical definition that I could here mention from the standpoint of the high courts in Brazil, especially the superior court of labor rights, or the TST, which is also to downgrade the social protection of workers when touching or interpreting the new trends and categories of work performed within digital platforms, as if this work wouldn't be the same work as employees or workers did in the past. And for that reason, this misguided, I would say, I wouldn't say non-voluntary, but on purpose, for instance, intentionally misinterpreted, misguided, in order to also downgrade workers and individual labor rights to a very lower ground of protection, which is something, or level of protection to be more accurate, a level of protection of those rights. So this is why CEDAW project and this idea of disseminating the importance of this project has to do with those concerns from the standpoint of policy related to the social protection of workers in digital environments. For example, workers carrying out their activities or tasks within digital platforms, and not through digital platforms, which is a very unique distinction, but also a nuance regarding the definitions, which is to work with them and work throughout, or I would say by means something. So this distinct terminology would also affect the way how those rights are enjoyed, social rights, particularly in the domain of labor rights, and how they are, in the end of the day, also put into this downgrading approach by domestic courts and also legislators, which is more than a liberal reform of the legislatures to subject the workers to lower degrees or levels of protection, but rather to subject those workers to the particular cognitive and narrative universe of digital platforms and their particularly private regulatory frameworks. Meaning, this is not important anymore what is about collective bargaining agreements by the workers as envisaged by labor law, as we know, for the substantive labor law, as you know, nor even to deal with new categories of individual labor rights, which are protected under a social umbrella of the domestic labor laws applicable to those relations. No, we are now moving to a more sophisticated narrative by which the categories of labor, as we know from the past, are subject to this intentional refinement given by platforms and subjecting the worker to those particular private regulatory frameworks, terms of use, rules of community, or even the idea that the self-employed or self-standing worker is someone who is a partner, who is also a collaborator of the platform as such. The same idea, I'm just giving an example that can explain this particular aspect, is not to talk about the proprietor or even the owner of an apartment or real estate from one side and talk about them as a host from one side. For example, what is behind the terminology used by private instruments or terms of uses of the famous booking platform, as we know, booking.com platform from one side. On the other side, to define the tenant, the lessor, the one has contracted a lease agreement, for example, as a guest. So this refinement about the language or the wording used also in those instruments is very pervasive. is very, I would say, ingerent. They interfere with the way how legislators will produce the new statutes. So it affects the lawmaking process, the narratives, the lobbies, the new understandings, or I would say narratives that are behind those new categories or new framings, and also will influence courts, particularly labor judges, who will be very, very seducted by the appealing wording of those platforms, in a way how those narratives are in the way how those narratives are set on the table. And this is the same what happened during the negotiations of the ILO binding treaty or draft treaty regarding the work performed in digital platforms. So this is something very unique in these terms, and that's why it's important for us to understand the context, the reality of those events, processes that are behind subjects and legal relationships, typically those that are captured by labor law from a substantive point of view, either individual or collective labor law, and how those categories are also very influential in those negotiations, especially the negotiations of the current ILO draft treaty, 2004, 2024, 2025. And now, in the next ILO conference, the potential adoption of this treaty, which in fact was, I would say, I could say a successful experiment in terms of trying to revert or to somehow stand this process in international at the international, on global scale or international level. But what's most important here is also to understand how the standards that are now under discussion by the ILO members, including Brazil, European Union countries, or member states of the European Union, under the auspices of the ILO, has to do with this tradition of those countries to preserve the main rationale behind the social protection of workers also in digital environment. For example, we know that in the European Union, there are estimatives or indicators that around 28 million of EU platform workers are integrated. And Brazil, for example, is experimenting a rapid growth in app work with disputes over subordination with regards to recognition of employment relationships by the domestic courts in Brazil. So this is something also unique, because in first instance and second instance courts in Brazil are appeal courts like the TRT in Brazil. There is a movement to capture those reality of forms and say that the work performed by workers in platforms can be, I would say, assimilated as the original work, and therefore this category will be refined under also the protection or social protection of workers and the recognition of employment relationships based in a contract. And this is something. But then the risk is when those cases are adjudicated by the superior court, and this is something what is behind, and the Brazilian TST is not looking into the particular and uniqueness of this process as the context, and also in some chambers or divisions or groups of judges in the TST, and that this main rationale is not understood or deliberately not understood to favor the huge platforms that are nowadays setting the standards of the work carried out in digital platforms. So this dispute between narratives and also the comprehension of judges and the litigants in those proceedings in first instance courts and second instance courts nowadays also have to look into the particularities and the idiosyncrasies of the main categories that are now interacting with labor, in particular workforce, and also the way how individual workers are engaging with such platforms. So concepts of task allocation, scheduling, automate performance, dynamic payments, which has to do with the way how those work is carried out, for example, for a Uber driver, and how this Uber driver is programmed to receive the fees of the service that he rendered to the fee that he rendered to the transport, to the individual that was transported, the passenger, and not by the platform as a payment of a salary, a wage, for example. So these distinctions regarding categories will be somehow discussed by the courts in individual cases, in collective cases. So that's why it's so important to understand the consequences of, for example, characterizing a particular legal relationship as a service relation or rendering of service, or when they are categorized or characterized as an employment relation, which is not a very, I would say, simplistic or reductionist approach for the courts to get into, but they are very important in the way of how the interaction between workers in digital platforms is in spotlight, is in the end of the day one of the most important discussions. So this focus on subjects, the workers, the platforms, the actors, this focus on the relationships, whether this relationship is behind a traditional employment relation, or this is a new reconfigured, remastered, or redesigned legal relationship based not anymore in employment, but in a simply contractual service provision, which is what main platforms are trying to push in their interests, in their stakes in these disputes. But what is a very unique opportunity and moment for us, being jurists, being lawyers, being researchers, to engage with this particular topic also when they are related with this the main concern of the CEDAW project, safeguarding employment digitally organized workers. I'm trying all the time to recall the importance of CEDAW project within the framework of the Cattedra Italica, within the framework of the exchange between University of Minas Gerais, University of Sanu, and other universities in Italy and Europe in a broader sense, because this is something unique for this field of research, field of practice, and also a field of a very experimental text that could be put into challenge, and also to understand how we could challenge those, how could we challenge those preconcepted categories and terminologies that are nowadays and to the present being discussed in these particular cases in Brazilian and EU courts, and also in this case, how to manage those categories, definitions that come from the digital environment, the digital milieu, and how they are somehow important to reconfigure what we understand about the social protection of workers. how there is a desirable field for exploring, researching, and critically engaging with these or those particular topics in international labor agenda. That's why we are here unfolding, we are discovering such intricacies and such unique approach to the work digitally carried out in platforms, the platformized works. So those aspects are very important. And coming to the third and last part of this presentation is, of course, once again, to focus on this, I would say, step-by-step process coming from international legal arena, from the ILO, the work already carried out by the European Union, thinking about the importance of the ILO as an international organization dealing with normative issues related to the protection of workers in international arena on global scale. That's the comprehensive approach of the ILO norm setting by establishing treaties, convention, which have been adopted for many years since the creation or establishment of the ILO, the recommendations of the ILO, the importance of the committees of the ILO in several fields. And this is a very important aspect related to the work of the ILO as an international organization. The participation of member states, the participation of the unions, the employees unions, and also the industry. So in this three-step or three-level approach to the norm setting in the ILO work, and also how this agenda now is receiving these new inputs, these new developments related to the work carried out in digital platforms. But before that, it's important to understand that for many years, I would say 2 decades at least, ILO has engaged with the decent work agenda. And there also the ILO under the diplomatic conference, the ILO conference, which is comprised or consists of the three-partite structure, which is the member states as delegates, the unions. This is very important to understand. The workers and also the industry, and also how this agenda also competed with a parallel agenda of the ILO, which had to do with the future of the work. So the idea behind those political agendas in the ILO, thinking about their repercussions to the social protection of workers in digital environments, and particularly the work carried out by workers in platforms and digital platforms, is not something to be overstated, meaning we cannot simply disregard the importance of those two agendas, which are political in the end of the day. They have to do with the politics behind the way how the diplomatic negotiations are carried out by members, but also the public policy behind the idea to strike the balance between interests amongst the member states, also the trade unions and the industry from one side, and on the other side, how to keep the International Labor Organization, the ILO, committed with a very universal principle, which has to do with the social protection of the worker. And that's why in this set or a number of treaties and conventions that were already adopted by the ILO, there is a concern by the organization to make them effective and also to monitor, to oversight the application or enforcement of those treaties by ILO member states. So when the ILO produces reports, individual reports or national reports on particular member state to detect, to check, to scrutinize to what extent this member adopts, incorporates, and enforce those international legal standards, labor standards, and also how those countries implement those treaties and their obligations, the ILO is sending a message to the domestic legislator or to the courts in a particular member state why those member states are compliant to the ILO instruments or to what extent those member states are not compliant with those international labor standards and implementing or are not implementing those ILO fundamental conventions, for example, which are by chance very important because they deal not only with the dignity of the worker, but also they deal with social protections and guarantees related to the work performed by the worker, the way how the work is not only exploited from economic point of view and generate surplus, or what is behind the idea of traditional idea about the exploitation of a work, generation of income, and also consumption for domestic economic systems, but also under a capitalist system or approach, but also to understand how those social guarantees would apply to social workers within international level and how those member states and their legal systems will be compliant with those international labor standards. So we have two agendas, the decent work and also the future of work. But the future of work is now under scrutiny because the main discussions coming from national conferences and also within the diplomatic conferences carried out by ILO, especially in those to adopt the draft treaty on the work carried out by platforms, is, in the end of the day, one of the most important steps given by the organization to somehow recover this original concern back to the end of the 19th century, in the beginning of the 20th century, which has to do with the social protection of workers and those very minimum rights assigned or ensured to the workers at global level, on global scale, would be one of the most important rights in the end of the day, and how this developed to a very coherent system of progress, development, and further deepening of rights assigned to workers in terms of recognition, affirmation, and enforcement, respect. And also this interaction with fundamental rights of work, which is something unique in this dimension between the ILO and ILO conventions and treaties from one side, and international instruments dealing with human rights from other side. I'm talking about the UN Declaration of Human Rights, the International Covenant on Civil Political Rights adopted in 1966, the UN or International Covenant on Economic, Social, Cultural Rights of 1966. In Brazil, we're talking about the human rights, American Human Rights Convention, or the Pacto of San Jose. Which is very important for Brazil, particularly due to this the binding nature and also the case law jurisprudence of the Inter-American Court of Human Rights, and within the EU level, the sort of international instruments which are not simply regional, and also the normative instruments of the EU, particularly EU regulations and directives which somehow make reference or express reference to the EU Charter of Fundamental Rights, to state that the work carried out by workers in platforms have to be also aligned with the main obligations of member states within the European Union in connection with the EU Charter of Fundamental Rights of 2002. So this is something important to be remarked here, this interface or interplay between international labor standards or international labor obligations arising from ILO conventions implemented by member states like Brazil from one side, and on the other side also this interface with the international human rights treaties, conventions, or instruments, which are very important in the end of the day. And that's why the work carried out by the ILO in this field is also very important. Since we are now talking about the proliferation, the multiplicity of instruments dealing with some aspects related to the protection or social protection of workers in digitally integrated platforms. And this is something that I would like to remark in this presentation, because as far as I'm concerned, this was the first opportunity from the standpoint of ILO norm setting agenda from one side, and from the other side, also from the university research level, particularly here at the University of Minas Gerais, to engage with this main opportunity to understand how those different legal regimes in terms of labor and social protection of workers from one side, and on the other side, how those international instruments dealing with human rights would also be applicable in this context, and particularly to reach those relationships between workers in platforms and digital platforms, and how those relationships, apart from being legal as such, a legal relationship or a transaction, they will entail the application of human rights provisions, particularly in those countries which are bound to international treaties or human rights instruments that are binding by nature. And this is why this is unique aspects so important also for Brazil. And now I'm here just making a small digression to understand how to state how Brazil also has to be concerned about the implications of having new terminologies, categories redefined from the standpoint of the digital agenda, and how this is what I mean very important in this aspect is how to understand how Brazil, particularly in the jurisprudence of the superior courts or high courts of justice, and also the Supreme Court, the Brazilian Supreme Court, our constitutional court, will deal with such interactions, because this is something unique, not only in those cases which are now adjudicated by the Brazilian STF or Brazilian Supreme Court, Constitutional Court, in those cases that are under the jurisdiction of the Brazilian Superior Labor Court, the TST, which is important also for those cases who are final in terms of the appeal level, and how those cases will lead the court to decide on merits of cases that are very important to define, in the end of the day, the precedents, the case law behind those particular disputes, litigation involving the relationships between workers and platforms. And so to say, in other words, how the future of those relationships between workers and platforms will be defined from the standpoint of judicial law. So the work of courts and how they can be, I would say, consistent with the enforcement of human rights provisions from the Brazilian constitution or even from the treaties and conventions to which Brazil is signatory and ratified and are enforced also to Brazil. And what is more important, to redefine the way how work, even in digital platform, is considered work, and how considered as such can also be entitled to the main guarantees and social protection rules that are envisaged or ensured by the Brazilian legislation. And when I talk about Brazilian legislation, I'm talking about what is about domestic law, pure domestic law in Brazil, but also international law binding Brazil, international obligations to which Brazil is bound. And there are several of them under ILO or under ILO perspective or under the Inter-American system of human rights, which is also very important for Brazil. And this is a very unique perspective because according to the National Council of Justice resolution, Brazil is bound to decisions rendered by the Inter-American Court of Human Rights, or decisions that come from the Inter-American system of human rights. And courts have to obey and have to be deferent to those decisions rendered by the International Court of Human Rights within the Inter-American system. That's why also in labor-related disputes, and I'm talking about labor law disputes, disputes surrounding the social protection of workers, also under individual and collective labor rights, but also the new wave or trend of cases that are coming now to the courts involving the relationship between workers and digital platforms. And that's why this deference to the decisions of the Inter-American Court of Human Rights in the case of Brazil is also a mandatory deference. So the courts, even the labor courts in Brazil, have to be, I would say, compliant with the degree of protection which was ensured by those decisions by the Inter-American Court of Human Rights, which is important. So what remains to be seen in case of Brazil, of course, is this relationship between, or interplay between treaties, human rights treaties, the ILO conventions, and potential the future ILO convention on the work carried out in platforms, which is one of the most recent instruments under negotiation by the ILO members. So that's why it's so important. And also to the existing ILO treaties in force in Brazil, since we are talking about 98 treaties ratified by Brazil and in force to Brazil. And also for that reason, also enforceable within particular cases adjudicated by courts in Brazil. So this is something that I always talk about, the practical operation of international law by domestic courts and legislators. So it's not an excuse for the domestic judge to say that the domestic judge is not aware of the existence of international instruments or the international law, because international law in case of Brazil is part of domestic law. So the old Latin expression that iura novit curia says that the judge cannot excuse that he doesn't know, she doesn't know the law as such. And the law as such can be what is behind the statutory law, the treaties and conventions that the country, that domestic system incorporated into its domestic legal system, or in this case, what is the case law behind the doctrine, and what is behind law as this express the outcome of what can produce, what can reveals, what can expresses law as a source. So this idea is very important even for the judges, and I'm afraid if the judges simply rely their adjudicating task to AI tools, for example, artificial intelligence tools, if the artificial intelligence tools will be intelligent enough to cover all the bulk set of rules that the judge has to know or should know in order to perform his or her task of deciding that case. And in labor law disputes, especially those who are currently now put into the courts tables in Brazil, is a question to be solved under the way how the judge exercises a adjudicatory jurisdiction of the state, which is one parcel, which is one aspect or feature of the jurisdiction of the state under its sovereignty. So this is a very important task in this aspect. To certain extent, and I'm just coming to the conclusion that the statutes of those instruments in domestic law or in legal systems, domestic legal systems, national legal systems for a country like Brazil, much more distinct from the EU system, as, for example, not only the EU Charter is automatically applicable to EU member states, the EU Charter of Fundamental Rights, or the treaties establishing the functioning or the European Union or the functioning of the European Union, and further international instruments adopted by the EU member states under international level, and within the EU level, the regulations and directives which are also binding by nature, and therefore the courts of EU member states have to apply. Am I talking this about the importance of one of the two, I would say, main pieces of legislation or EU legislation, which have everything to do about what we are discussing here, and that have everything to do with the comparative exercise that we do in terms of legislation experiments, legal experiments in Brazil. Meaning those instruments adopted by the EU that serve as a comparative experiment to Brazilian legislators, courts, and also for the Brazilian scholarship, the doctrine, when doctrine is used for purpose of establishing standards and compromises related a particular understanding about law is applicable, how law has to be construed, interpreted, and so on and so forth. But what is for us Brazilian scholars, jurists, lawyers, a point of reflection and comparison, and not a plain comparison, but to understand how those instruments would operate with Brazilian legal system, also to ensure a certain level of protection or social protection to workers carrying out their labor or working activities within digital platforms. This is something unique. And those two instruments I would quote here are, of course, one of the most important, in this sense, the directive of the the EU directive, on improving working conditions in platform work. This beautiful name of the PWL EU directive. The EU Platform Work Directive is nowadays very influential to what Brazil is deciding or discussing, in particular due to the analysis or scrutiny of the Bill of Legislation number 21 of 23, which is now under the work of the Brazilian National Congress. And this Bill of Legislation is trying to mirror some of the social and comparative practices related to the protection of workers in digital platforms. So this is a very important step that Brazil is giving in order to follow up and also to be aligned with those trends in social protection of workers in digital platforms. Of course, there is much space for discussion. There is much criticism related to the EU directive and the Brazilian now formula or Brazilian recipe for this particular aspect related to the protection of workers in digital platforms. But this is a policy choice from one side and also a public policy in labor relations related to the protection of workers in digital platforms. And the idea is how to cope and strike the balance between interests of, for example, the protection of workers from one side, and there is another interest on the other side, some type of opposing conflict, which is to ensure that as they say, typically the costs of social protection in digital platforms will somehow impair or make difficult the path of innovation or development of new innovative solutions by those platforms. But we know that this kind of discourse or narrative has been adopted by industry in the past and tech industry and now big techs for many years, decades, centuries, and the same, I would say, narrative never prohibited or refrained states, societies for taking the lead and deciding how they desired to protect that particularly realm or domain of social life, and which is important for labor. At least this is a very personal opinion. I'm here stepping from all my tasks from a law professor, a jurist, or even a citizen, but saying as a human that the social dimension of the labor's relations has to do with the perception of how the life of the worker, the family, has to be better and not a very hard time, as Charles Dickens once posed in the end of 19th century when he focused on the Victorian England and saw the misery that was made by the families, the corruption of social values by the velocity, the speed of the development of the industry, and also the scientific, industrial, and technological discoveries and inventions that were in stake at that particular point of time. So it's important because there is a social critique on how even technologies can make the life of individuals, families, groups, communities more miserable. And this is something very important as recovering some human aspects and human-centered concerns to defend and to contend that's important to improve the life of workers and not simply to put them in very strict downgraded terms, downgraded conditions, downgraded feelings, particularly in those situations where everything has to do in a comparison what happened before between the enthusiasm and also the skepticism of individuals of the society in the end of the 19th century when a kind of feeling of anguish, a kind of a mixed feeling of, as I said, optimism from one side, but also from the other side, anxiety in relation to the speed and the number of scientific, technology, industrial developments that the revolutions in the end of 19th century revealed to the society, particularly in the case of Europe at that point of time. I mean, I'm just comparing here because as a overarching value for social protection of workers within domestic and international legal systems, there is this underlying concern which has to do with improving not only the well-being, improving the happiness, improving the way how we have time to rest, to be engaged with leisure, to be engaged with our family, to constructing and reconstructing our personal relationships, our affections, and so on, but also to the extent that we couldn't be simply monitorized, supervised, or even to control by the algorithm power or powers and the subordination as such as evolved, because the subordination is not only about the single relationship between the worker and the digital platform as such. This has to do also with extension to the worker's private life and the life of family that could be affected by the way how those forces and the algorithm control could have or could affect on those family members within the life of family as such. And here there is another very intuitive approach coming from the interaction between international labor norms from one side and international human rights, when to an individual is ensured and protected his or her right to the private life in family, which can be somehow disturbed, affected, or interfered with when such pervasive, aggressive, invasive mode of control coming from the digital platforms also interfere with the life enjoyment of life in family or leisure or rest and happiness in case of the worker which has been subject to such extensive control by the platforms. So imagine the way how all those concerns that we have nowadays regarding the excessive time in screens, the excessive time consuming online content, the excessive time scrolling posts and online content in social networks, and how those excessive time we expend doing that particular tasks would also be combined with that in terms of the work carried out in platforms. So this is something related to not only the future of work as the agenda of the ILO, but also with decent work in terms of ensuring this the level of social protection of work, which has to do with a very compromise of international legal order. And so some takeaways that we can provide for this presentation. And the first is, of course, to understand how the interplay between the international legal framework, particularly in this case, the ILO norm setting, coming from the potential adoption of a draft treaty dealing with the work in digital platforms from one side. The second is the interplay between the EU experiments and experiences practices in this field, particularly with relation to the Digital Work Platform Directive, to the extent to the European regulation in artificial intelligence also protect affected persons or individuals in those interactions with AI systems of high risks, which is something also that was transposed to the Brazilian Bill on Artificial Intelligence, and high risk under a conceptual definition coming from the EU regulation, and also encapsulated by the Brazilian Bill of Legislation on AI, the future Brazilian legal framework on AI, artificial intelligence, has to do with those systems or AI systems that can how or somehow have the impact or likelihood of impact the fundamental rights of the individual. So if somehow this AI system, which has to do to the control that platforms have under the worker, under the work privacy, under the worker intimacy, under the worker well-being, could be also potentially listed or classified as a AI system with high risk or high risk AI system, which is something unique. In this case, the worker, the digital platform, has to comply with several obligations as established, for example, in the EU regulation or EU AI Act, and also in the future Brazilian AI Act, which is to implement a impact assessment study or report, which deals with this impacts over the life of individual, which is, in the end of the day, the enjoyment of fundamental rights by this affected person. It's interesting because the AI Act in European Union and the Brazilian future AI Act deals with a category, because it's not about a right subject, or it's not about the owner, it's not about the entitled person, but it's about the affected person. So the subject towards which this AI system, the computer, the program, the software, the platform, in the end of the day, is related, is the affected person. So there are obligations from the platform, the service provider, the digital platform, which is hosting the work of the worker, if we can put so, has to, in compliance with the rights of the affected person. So this is a new category of rights, actually, because we're not talking about simply of fundamental right of the individual or the worker, but we are talking about some rights of the affected person. And who, in the end of the day, will be the affected person? The worker, the citizen, the voter. So this is basically what is behind this new trend of legislative experiments or pieces of legislation, statutes, like the regulation, the EU regulation, the AI Act, and also the future Brazilian AI Act, which has to do with this also level protection of the affected person, which is not only a human-centered approach, given by the fact that the platform is obliged, is requested, is required, shall be doing something which the law establishes for, or in the end of the day, how this affected person is also subject to rights addressed by categories and frameworks that will ensure or guarantee a level of protection when those cumulative relationships are into question. One is not only the labor relationship as such, the work as carried out by the worker, the individual, the affected person, but also that particular level of relation where the individual also is affected person, and therefore, if there is a high risk AI system into consideration, so this developer, the one who is operating this AI system, has obligations to comply with, and therefore this is something unique in this new perception, this new perception of relationships that exceeds the current comprehension, understanding surrounding work, labor relations, as we know, but deepening to other instances in level of reflections. And just to conclude, it's important for next steps, the takeaways that we have in this particular topic is that we should be able, especially here, the audience, discussing issues related to labor and new technologies, discussing new trends, even for research purposes, between law, labor, and emerging technologies, that we are able to navigate those new concepts, categories, environments, understanding how technology operates, how it's constituted, how those, for example, platformized work, or how those AI systems today embedded in those or embodying those digital platforms are configured, and in this sense to unfold the main demands for social change transformation, which is also behind the idea of labor law as such, to promote a social change, to improve the life of workers, to improve the level of protection, social protection of the workers in terms of how they also integrate, interact, and transact with the platforms, which is something unique in this purpose. So this is the main, I would say, learning process to which we have to engage. How we engage with that? Well, first of all, understanding the scope of the scope of operation or functioning of those platforms, and how they deal, in fact, in reality, with those workers, and how those platforms will be also subject to multiple layers or levels of obligations, binding obligations coming from international law, labor law, human rights, to domestic law as such. So we are talking about the confluence of different legal regimes, from labor and social protection, from AI perspective now, and also for the constitutional human rights dimension. So thinking about three circles that could be intersected together. And the first is the legal regime to most of you are very familiarized with, which is the labor and social dimension of protection. And then we are talking about labor law and social law, as we know. The second, the one related to AI, now it's the current one. And the third, of course, a very overarching, which is the one constitutional / human rights dimension, which is very important to this exercise that we are doing. So for Brazil, and I can say the same for the European Union, not as a speaker, although I could, but I prefer stick with the compromise here, with the compromise to make this exercise to Brazil, which is to focus on the importance of this discussion and contemporary debate for Brazilian audience, which has to do with the 2024 Bill of Legislation, App Drivers Bill, where there is also a main concern related to the self-employment or self-employed category with social rights. So emphasis on ethical dimension, also for platforms, but also recognizing some developments that were achieved by the courts in Brazil. So under judiciary, at the judiciary level, what they say atypical subordination, which is a beautiful or not so beautiful name to define something that was downgraded from the typical subordination, which is necessary for recognizing the employment relation as such, and therefore subject to the social protection of labor rights, as we know, individual and collective rights. So that's why when we downgrade a category, trying to obfuscate or to hide a particular aspect of that relationship that has to do with the labor relationship in nature. So in the end of the way, so the outcome would be another one for purpose of enforcement of labor rights. So that's why this accuracy on the way how we interpret or redefine such categories will have impacts over the enjoyment of social rights for workers. So the courts in Brazil have to establish a self-exercise, also self-criticism, and say, are we moving to a new regime where those social rights for workers in digital platforms have to be downgraded? Or are we trying to adapt such categories to those already existing and incorporating new elements, features to those relationships? And if we are talking about the traditional labor relationship, not specifically discussing the way how the employment category is recognized by force of law based on the existence of an employment agreement as a traditional defined, but giving a step further and understanding that there are hidden categories that can obfuscate the enforcement of social rights, and therefore it's more than a simply legal technicality related to interpretation of a category, but a policy option or choice made by the court to downgrade those relations in view of the digital milieu, in view of the digital interaction between the worker and the platform, this digital as such, digital as an environment, digital as a milieu, digital as a medium. So the idea of digital cannot obfuscate or hide, this is very important, or simply set aside the reality of the work, how the work is done, how the tasks are performed, how the labor force is explored or exploited, which, in my opinion, are categories that are crossing time, decades, and even, which is more important, traditions, and even legal traditions about the systems, legal systems. So the way how work is done, how the worker is somehow subject to the consistency, the habitual activities or tasks that he performs or she performs in order to comply with rules of a implicit or a express contract or agreement, which is something also unique for purpose of those exercises that we do in terms of defining or not defining those categories of relationship. So I just brought here some of these perceptions because in case of Brazil, my concern is related the way how the enforcement of social rights by labor courts in Brazil will not be hindered, will not be put aside simply by the fact that the courts are being seducted, or they are being somehow more than that, witched as a witch, when the witch simply bewitch, the word in English, bewitched by the narratives of the big techs and the digital platforms trying to, or in their attempt to deconfigure or even to downgrade the understanding, the comprehension of the courts and lawyers about what is behind technology. Because this is a very important aspect. Once we know what is behind technology, we are able to confront and to dispute those understandings that are simply exported by some groups of interests and lobbies to another sphere or another realm of political discussions, and trying to obfuscate the reality of forms. And once again, I'm talking about an international lawyer, not only, once again, a labor lawyer, but international lawyer concerned about those categories and those feelings. But something I never forget from my labor law classes from the law school, that the most important rationale from the standpoint of interpretation, from the lawmaking, from the judicial adjudication of cases in labor law, is that what is more important is the reality of the forms, the reality of the processes, and not the appearance, the simulation, or in some sense, what I said, this bewitched way to think about how technologies changed the way how the worker has to be protected. And this is something very unique in this whole discourse. If we go to the several fora and domains, places, tables where this topic is discussed or being discussed, because you see about that in the end of the day, the worker is the worker as such. The way how the worker has been exploited, subject to new ways of use of his or her force, his abilities, his skills has been the same. But the medium, the way, the environment, the milieu has changed. And so that's something that you have to understand. And if I can finish with that, so a message for the topic, international labor law and emerging technologies, is that also the international labor lawmaking, norm setting, and what is very important in this work together with the International Labor Organization and member states, trade unions, and also the workers, is to understand how the nature, the development, and the understanding surrounding technologies have to be very well captured, have to be understood in order to, once again, dispute such narratives that could be downgrading the social protection of workers within digital environment, which is very important. So to make a very alignment here as to the CEDAW project, Safeguarding of Employment in Digitally Organized Workers, is that the fronts are very important, particularly for the Brazilian audience. One front is the ILO current negotiation of the draft treaty on the work, the protection of works in platforms, in digital platforms, and also the work carried out in the National Congress related to the Bill 21, 2024, which has much to aggregate in terms of what has been said in this way. So Brazil, as a European Union, in these external relations, and also the whole tradition that Italy had in the past with the trade union development and emergency, and in the contribution to the history of social law and labor law, as we know. This is very influential for Brazilian lawyers, not only because the Italian legal tradition, the Italian statutory laws, codes influence the Brazilian legislators, the law schools, the way how the case law and also the jurisprudence and also the scholarship and doctrinal approach has evolved, but also to understand how these lessons could be learned, how those lessons could be also disseminated in the world. So just to conclude, those are my contributions to this debate. And I, once again, thank you so much for your attention and for the audience. And once again, just a spoil of that, for those who are very interested in the topic, in the next months, at least in this first semester of 2006, we are going to launch workshops and seminars discussing the human side of artificial intelligence and the challenges to legal research. So this is also something unique in University of Minas Gerais, but I'm very happy to have on board my esteemed colleagues, including Professor Maria Rosaria Barbato, in this main project, which is also a sister project to the Cátedra Itálica and also the CIDO project under the Jean Monnet module, which is now carried out by the University of Minas Gerais under the competent direction of Professora Barbato. Thank you so much. I give back to Stefano. Stefano, obrigado. Volto para vocês aqui para questões ou comentários que tiverem.
Thank you so much, Professor. I don't know, we want to proceed in English or in Portuguese? How?
I think we can. Podemos ir para o português, para o italiano, porque
Beleza.
nós encerramos porque acho que aí a ideia é encerrar a gravação para depois. Não precisa
Beleza.
mas a gente corta a gravação para subir
Beleza.
depois na plataforma.
Será a gravação?
Sim, nós encerramos aqui.
Ok, porque eu aqui estou ainda vendo gravação.
Sim, fato. Deixa eu ver se eu tô com a. Não, mas não tem problema, não. A gente pode continuar depois.
Sim.
Depois para.
Beleza.
Ótimo.
Então, muito obrigado, professor Fabrício, pela sua palestra, super interessante. E eu tenho uma pergunta para o senhor, tenho uma curiosidade. E, primeiramente, eu tive a sorte de fazer um estágio de docência com o senhor. Agora passou muito tempo, porque são já 2 anos, em 2024, quando eu fiz meu primeiro estágio de docência em Direito Internacional do Trabalho. Foi uma experiência super enriquecedora. Então, estamos muito contentes que o senhor pôde fazer essa palestra conosco. Então, mais uma vez, muito obrigado, professor. Agora, vendo a minha curiosidade, professor, então, a aula é sobre o direito internacional do trabalho, mas é claro que o direito internacional do trabalho faz parte do direito internacional. Eu, hoje em dia, estou um pouco preocupado quando se fala de direito internacional, porque, infelizmente, estamos vendo que o direito internacional está claramente em crise. E a gente pode ver isso com a guerra, né, que está acontecendo agora entre a Rússia e a Ucrânia, o genocídio que está acontecendo entre Israel e a Palestina, a guerra dos Estados Unidos e Irã. Enfim, estamos cheios de exemplos hoje em dia. o ataque dos Estados Unidos para a Venezuela. Então, nesse contexto de crise do direito internacional, eu pergunto para o senhor, sendo um experto de direito internacional do trabalho, como, em que medida o senhor acha que o direito internacional do trabalho, em particular modo as convenções da OIT, pode ser suficientes para regular essa transformação tecnológica muito forte e eh, gente que está acontecendo agora em todo mundo, nos lugares do trabalho, sendo que a gente, infelizmente, está vendo que a realidade e a lei do mais forte é mais relevante que o direito, a certeza do direito, o princípio de legalidade da pena. Então, embora claramente o direito internacional que está sendo provado nesses dias, eu diria que mais o direito internacional da guerra, criminal, e, enfim. Mas mesmo assim, tem lógicas de poder muito fortes no direito do trabalho, ainda mais com esses gigantes tecnológicos que estão dominando a revolução industrial 3.0, podemos, ou 4.0 ainda melhor, hoje em dia. Então, a minha pergunta é essa, basicamente, professor. Como o direito internacional do trabalho, os padrões do direito internacional do trabalho, é, é, das convenções da OIT, podem ser suficientes para regular essa transformação tecnológica fortíssima hoje em dia? Muito obrigado, professor.
A pergunta, Stefano, é uma pergunta absolutamente atual e ela promove uma necessidade de reflexão a respeito desses limites, mas também potencialidades que o direito internacional do trabalho teve ao longo da história, pensando na sua defesa, eu diria que institucional, ponto de vista da construção da organização como tal, suas funções, atribuições, dos seus programas, da atuação de comitês e como nessas mesmas preocupações vieram lá do início, no final do século XIX já, com as primeiras convenções do trabalho ainda fora do escopo ou da estrutura da Organização Internacional do Trabalho, já que a Organização Internacional do Trabalho nasce como um produto da Liga das Nações, isso é muito importante, e segundo, porque a Organização Internacional do Trabalho adotar, por exemplo, as primeiras convenções fundamentais ou administrá-las, como eram as convenções anteriores, trouxe a necessidade dos estados de alinharem padrões, práticas, a sua própria conduta como Estado nas relações exteriores para as questões laborais. E uma delas, se nós pensarmos que as primeiras convenções para erradicação do trabalho infantil, por exemplo, e trabalho e convenções que foram lidando com aspectos da saúde ocupacional, das questões de insalubridade do trabalho, todas elas foram convenções absolutamente pioneiras ao tempo em que não havia saúde ocupacional, não havia proteção laboral contra a insalubridade e também exploração do trabalho infantil. Então foi um percurso evolutivo. E acho que essa talvez seja uma das principais dificuldades de entender que o direito internacional também, nos seus instrumentos, instituições, mecanismos de aplicação, de fazer valer suas normas, não foi construído e se desenvolveu sem esses desafios, sem essas dificuldades. E o que nós estamos agora experimentando, nesse momento, não é diferente. Nós estamos com desafios muito parecidos e que remontam, sim, a situações lá anteriores à Primeira Guerra Mundial, porque naquele momento não havia ainda a consensualização, o entendimento de princípios que foram fundamentais para assegurar paz, segurança da ordem internacionais, a cooperação internacional, que tudo isso é trazido dentro do espírito onusiano, ou seja, da ONU, pós-1945. E para a OIT não vai ser diferente, sobretudo porque a OIT depende, como é uma das mais importantes, acho que afirmações de quem são os juristas laboralistas internacionalistas, né, os jus internacionalistas laborais, de que o direito internacional do trabalho é um dos poucos campos que se constitui como um direito de ingerência. Por quê? Porque de uma estrutura tripartite nas organizações internacionais, que é única, como é o caso da OIT, pelas decisões nessas conferências serem dos três partes, esse é um ponto importante. E segundo, porque para que essas convenções da OIT sejam aplicadas dentro dos estados, e pelo menos os países têm levado isso em consideração, na experiência da própria OIT, que regularmente publica os relatórios de aplicação, implementação das convenções, é de que esse trabalho só existe quando a organização e os estados e outros atores, stakeholders, estão integrados e empenhados nesse contexto. E por que eu falo isso? Porque no Brasil também as organizações sindicais, dentro da trajetória do sindicalismo brasileiro, foram se conscientizando da importância de trazer, por exemplo, instrumentos internacionais vinculantes e, mais recentemente, a prática da proteção dos direitos humanos dentro do sistema regional brasileiro, do sistema regional interamericano, né, do sistema interamericano, para a prática doméstica, para a prática interna. Então, é claro que isso continua colocado sob evidência, mas é a mesma resposta que eu dei recentemente para alguns que questionaram essa mesma pergunta, fizeram essa mesma pergunta. Se nós pensarmos que ao longo desses anos, os instrumentos internacionais, as instituições, as organizações continuaram existindo, se mantendo, ora em níveis maior de aceitação e aplicação, observância, ora em níveis menores. O que nós estamos vendo agora para algumas áreas são níveis menores. Por exemplo, no campo do trabalho, no campo do comércio internacional, o esvaziamento do OMC, no campo das relações políticas entre os estados e as situações envolvendo paz, segurança, cooperação, que estão no domínio das Nações Unidas, da Carta da ONU, dos instrumentos que a ONU adotou e promoveu ao longo da sua existência e operação, mas nós também continuamos com campos que permanecem atuantes, funcionando, e o direito internacional não parou para essas áreas. Eu falo do sistema de comunicação, do controle de transportes, aviação civil, propriedade intelectual, próprio funcionamento, e isso acho que é muito importante a gente pensar, das fronteiras e fluxos migratórios, com seus altos e baixos dentro dessa política. Então, claro, são vários os domínios e vidas que a gente poderia aqui contar, mas sobre especificamente o direito internacional do trabalho, eu acho que essa percepção tem que ser vista em evolução. Quantas décadas foram necessárias para que esses instrumentos fossem sendo adotados? E aí também vai depender, mais uma vez, dos estados, seus sistemas domésticos, nessa tarefa de aplicação, ou continuar aplicando. Se nós pensarmos no Brasil, é tarefa do legislador, é tarefa dos nossos tribunais continuar fazendo valer as regras, normas internacionais para que aquele estado continue sendo conforme e consistente do ponto de vista da obrigação, ou das obrigações, ou da observância dessas obrigações que ele assumiu na ordem internacional. Então, minha percepção é um pouco essa do que acontece, mas não tem como negar de que nós estamos vivendo, eu vou usar uma expressão que eu usei num artigo que vai ser publicado nesse semestre, tempos fraturados para o direito internacional. Então, antes de eu decretar a morte do direito internacional, como alguém um dia fez para a história, eu gostaria de posicionar com cautela para que esse momento que nós vivemos é um momento de tempos fraturados, né? Essa frase não é minha, essa frase vem de Eric Hobsbawm, de uma obra do final da vida dele, Tempos Fraturados, em que ele reflete sobre a forma como a arte e a cultura na sociedade contemporânea foram esgarçadas, foram rebaixadas a partir do consumo midiático, né? Aquela época ele já estava trabalhando as categorias de digitalização, as mídias digitais, aquilo que mais recentemente também autores como Habermas acabaram revisitando na sua obra desde a estrutura. Então eu não inventei essa expressão, mas ninguém nunca falou sobre direito internacional em tempos fraturados. Então eu me permiti essa comparação e analogia, quase uma extensão daquilo que Eric Hobsbawm observou a respeito dos tempos fraturados para a cultura, sociedade, política no século XXI, no final do século XXI, que foi justamente essa passagem dentro do que ele viu nas suas horas anteriores, né? A era das revoluções, do capital dos extremos e como que essas eras foram se sucedendo. Então, para o direito internacional não seria diferente, e eu acho que fica aí essa nossa mensagem, né? Mas obrigado pela pergunta, é uma pergunta importante, fica até gravado, porque essa percepção do direito internacional do trabalho também não me passou muito presente. E eu, observando a evolução da disciplina, das instituições, do papel da OIT nesse campo, é mostrar que ela tem enfrentado, ela não tem deixado para trás essa discussão, né? E eu acredito que um trabalho nosso importante é verificar como a OIT, nesse ano, na conferência dos membros, então 2026, vai fechar esse momento, esse circuito, ao entregar um produto normativo que é a Convenção sobre a Proteção do Trabalho em Plataformas. Então, acho que a gente tem aqui uma tarefa importante para discutir esse ano, né? Até lá nós vamos ter oportunidade de fazer um outro encontro só para discutir, talvez, o projeto, né, o draft, a minuta da convenção da OIT nesse campo, que é a primeira, né, inédita em qualquer outra essência. Não, acho que vale a pena esse trabalho. E um outro estudo exploratório aqui para o CIDL é falar justamente da Convenção Quadro da União, da Convenção Quadro do Conselho da Europa sobre inteligência artificial, democracia e o Estado de Direito, que é o último instrumento também, tratado vinculante, é o primeiro, na verdade, em matéria de IA, né? Porque o regulamento da União Europeia não é um tratado. A norma europeia tem uma outra natureza. Mas o primeiro instrumento vinculante multilateral é a Convenção Quadro da União Europeia. O Brasil não é parte, mas ele pode ser chamado a aderir à convenção. E uma das discussões que nós temos agora é entender um pouco isso, porque o exercício aqui é importante, entender como as reformas trabalhistas, das leis trabalhistas, a jurisprudência do trabalho no Brasil, países da União Europeia, se relacionam com esses instrumentos. De um lado, o regulamento europeu de IA, por isso para a União Europeia é importante, e também, no caso do Brasil, as convenções, a Convenção Interamericana e, potencialmente, se o Brasil for chamado a aderir à Convenção Quadro da União Europeia, que é agora de 2024, né, setembro de 2024, o Brasil teria, então, espaço para também ou melhor, né, se unir aos países que são membros da convenção. Curiosamente, Estados Unidos é parte, não ratificou a convenção, não denunciou. Eu não sei se o presidente atual nos Estados Unidos sabe da existência, mas talvez se ele souber, ele vai denunciar a convenção quadro da União Europeia, do Conselho da Europa, desculpe, European Council, aqui para não fazer confusão. E do outro lado, sobretudo aqui o Brasil como um espaço para esse instrumento. Então, acho que essas são as minhas contribuições aqui para esse debate sobre o direito internacional como um todo, o direito internacional do trabalho.
Obrigado, professor. Acho que eu precisava um pouco também de essa perspectiva mais positiva sobre a situação do direito internacional. Cara, a minha era uma provocação para a gente refletir um pouco sobre a situação global. Agora queria perguntar para os alunos se alguém tiver uma pergunta, uma curiosidade, uma dúvida sobre a palestra do professor, se quer falar alguma coisa, pode ficar à vontade. E,
E também, Stefano, se alguém tiver qualquer questão, quiser manter contato, pode me escrever dos alunos, inclusive pelas próximas semanas que estão. Desejo que aproveitem muito, né? Uma época no Brasil muito agitada, porque nós temos os feriados, o feriado do Carnaval é um feriado nacional. Então, com certeza eles vão aproveitar também essa experiência no Brasil. Aí, só para Stefano, eles podem me escrever também depois, nós não precisamos fazer agora. A questão aqui é que a
beleza.
faculdade precisa encerrar por conta do horário, né? Então, nós vamos ter que terminar mesmo pelo horário aqui, encerrar a nossa sessão.
Beleza, perfeito, perfeito. Ok, ok, podemos encerrar então. Muito obrigado, professor, muito
Obrigado,
obrigado.
Stefano. Obrigado. Uma saudação a todos.
Saudação a todos. Até o próximo encontro. Tchau, tchau.
Tchau. Prontinho. Missão cumprida com essa. Não foi? Não? Quem continua? Stefano? Stefano. Missão cumprida.
Eu professor, ainda tô, tô aqui.
Né?
Os alunos podem sair, né? Não, não é um problema. Podem sair.
Sim, deixa eu ver. Vamos ver se tá falando.
Boa tarde.
Ciao, ciao Felice, ciao Pietro, ciao Pierpaolo. Ciao, ciao.